Hello, good evening, everyone. Thank you all for joining us tonight. My name is Dhruti Shah, and I'm pleased to welcome you to this webinar on preparation of wills, gifting of property, nomination, and tax effect, organized by Affluence Advisory, along with its associated partners. We thank our associated partners for their inputs and valuable contributions. Talking about will is not just a legal formality, but it's your responsibility towards your family to ensure smooth passing of your assets to the beneficiary of your choice and preferences without disturbing the family values and harmony. Hence, understanding of nuisances of will is very essential, as any defect in the will or not preparing will may result in family disputes, and therefore, everyone, regardless of age, wealth, or family structure, needs a will. In this webinar, we shall be discussing the various aspects of wills, vis-a-vis types of wills, prerequisites of a valid will, registration of will, changes in will, etc. We will also discuss probate, letter of administration, succession certificate, gifting of property as part of succession planning. Apart from the legal aspect, we will also deliberate income tax and stamp duty impact on transfer of property under will or through gift. We are fortunate to have expert panelists belonging to the Affluence team who will guide us through these topics with clarity and insight. However, before I introduce you to the panelists, let's just know little about Affluence Advisory. Affluence Advisory, an ISO 9001 certified firm, is a multidisciplinary firm established with a vision to provide one-stop solution to clients under the dynamic and complex business environment. The Affluence Advisory team, which includes chartered accountants, company secretaries, corporate lawyers, management graduates, and other seasoned professionals, are committed to deliver quality services and assistance to its clients for more than 2 decades now. With great pleasure, I would now like to introduce our panelists for this session. To begin with, we have with us today Ms. Chaital Vaz. She passed her LLB in 2004 and became a solicitor in 2006, thereby a member of the Bombay Incorporated Law Society. She is a seasoned corporate lawyer with over 2 decades of experience. She possesses a deep understanding of corporate advisory matters, including investments, merger and acquisitions, joint ventures, and restructuring. Her proficiency extends to business transfers, various shareholder agreements, NDAs, contract drafting, and ensuring company and SEBI compliance. She has a rich expertise spanning industries like banking, real estate, IT, and more. She heads the legal practice at Affluence Advisory. We welcome you, Chaital ma'am, to this webinar.
Thank you, Dhruti, for the wonderful introduction. Looking forward to an interactive session today evening.
Sure, ma'am. Moving forward to another panelist we have today, that's Ms. Bhakti Thakker. She became a solicitor in 2023 and thereby a member of the Bombay Incorporated Law Society. She has experience in real estate transactions such as sale transfer transactions of lands and flats, leave and license agreements, and leases. Her experience expands to testamentary matters and general corporate laws, competition law, providing legal opinions and expertise in drafting the deeds and documents. She is a part of Affluence Advisory legal team and strongly supporting Chaital ma'am on several matters. Luckily, she is going to be the moderator too for today's webinar. Welcome, Bhakti ma'am.
Thank you, Dhruti. Thanks for the intro.
And lastly, we have with us CA Nimish Khakhar, who is a founding partner of Affluence Advisory and has more than 25 years of experience. He provides legal and financial consulting to clients. He also regularly delivers lectures on selected topics at various forums, including CA Institute and management colleges. We welcome you aboard, sir.
Thank you, Dhruti. Thank you for the introduction.
Moving ahead with the session, we got a few requests from participants to use Hindi along with English for greater clarity and better understanding of the subject. So, बेफिक्र रहिए, इस सेशन को हम आपके लिए जितना हो सके उतना आसान बनाने की कोशिश करेंगे. Now, without wasting any time further, let's begin with the session and I request Bhakti, the moderator, to take over.
Thank you, Dhruti. Good evening, ladies and gentlemen. I'm Bhakti Thakker. I'll be the moderator posing questions to our panelists, Ms. Chaital and Mr. Nimish Khakhar. So let's begin this webinar by answering the main question. Chaital ma'am, what is a will and what are the basic terms used in a will?
Before I get down to answering your question, Bhakti, let's look at the scenario which is extremely common in each and every household with each and every person. I'm sure all of us here, जो भी आज session attend कर रहे हैं, वो सब आप relate कर पाएंगे with what I'm going to say. All through our lives, we have two main aims. One is to work hard, obviously. Second is to build assets, okay? And all throughout, when we are in the process of building assets, we usually hear, I heard my father, my uncles, my relatives saying, कि जो हमें ना मिल पाया, we will try our best to make that achieve for our children or to keep that behind for our children. So a majority part of our life, first 20-25 years, we are busy studying. The next good 50 to 60 years, all we do is we work. We work to have a good home. We work to have a good holiday home, car, jewelry, investments, everything to have a good retired life and to provide a beautiful, relaxed, happy life to our next generation, right? Do you agree, Bhakti?
Absolutely.
Now, how is it that once we, during our lifetime, we worked hard and we've enjoyed the assets that we've built, पूरी जिंदगी मेहनत करके जो हमने संपत्ति बनाई है, how is it that we are going to pass it on to our next generation is the primary purpose where will comes into the picture, okay? What is a will, if you would ask me, एकदम सिंपल लैंग्वेज में, पूरे एसेट्स जो हमने बनाए हैं मेहनत करके जिंदगी भर, हमारे गुजर जाने के बाद वो संपत्ति किस किस को जाएगी, कौन से रेशियो में जाएगी, कितना किसको दिया जाएगा, वो जो हम डिसाइड करते हैं अपने लाइफ टाइम में, is something that we write down on a piece of paper which is called a will. To repeat again in simple language, आज घर, मेरे पास घर है, okay, it's almost sounding like a movie dialogue, गाड़ी है, फार्म हाउस है, ज्वेलरी है, इन्वेस्टमेंट्स है, but tomorrow when I'm not there, I need to make sure that some part of it goes to, say, my parents if they are alive, some needs to go to my spouse, some needs to go to my house help who's been with me for years, kuch jayega mere bete ke liye. So all these details that I will write, the piece of paper on which I will write, the document in which I will write will be the will. The wasihat is what we call it in Hindi. So a will is, in short, the document which comes into effect after a person dies. Okay. So I will write it. मैं आज वो पेपर पे लिख के जाऊंगी कि ओके मेरे गुजर जाने के बाद ये होना चाहिए. All right. So that in short is a will. And I'm sure next, Bhakti, you're going to ask me, which is a very, very common question, कि हमको will कभी बनानी चाहिए, right time आ गया क्या, madam? So I always tell people there is no need to wait for any good muhurat for us to कि भाई अच्छा मुहूर्त निकाल के अभी will बनाने के लिए जाएंगे वकील के पास. No. If you've not made a will until today, now is the right time. I will just give you a very unpleasant illustration which actually happened with someone in my immediate family just last Sunday. My cousin sister, my first cousin sister, lost her 39-year-old husband to heart attack. He just didn't wake up one Sunday morning. I mean, last Sunday morning was quite horrid for us, a 39-year-old person passing away. When we went to check, will hai ki nahi, the answer we got was, oh, he never thought that, it was time for him to make a will because rightly so, he was quite young. But as we all know, life, there's no guarantee, right? Today, one person's there, tomorrow that person may not be there. So from that perspective, as long as you are 18 years and above, and obviously the basic parameter being you have some assets to give away, now is the time for you to make the will. Okay? So, yeah, Bhakti, go ahead.
Thank you. That was a beautiful explanation beginning this webinar. So can you just explain our participants, now that you've told us what is a will, some basic terms which we can incorporate, like who may be the parties or what will be the flow in the will, if you could just explain it to our participants?
Sure, certainly. Whenever, जब भी आप वकील के पास जाएंगे will बनाने के लिए, it's quite often common कि आपको ऐसे एकदम भारी भारी legal शब्द सुनने में आएगा, which is testator, testatrix, executor, executrix. Please do not get scared. I will explain in simple language what this terminology means. If I am making a will, I am a testatrix. If Nimish sir is making a will, he's a testator. So it's the person who makes a will is called a testator. Agar female hai to testatrix. It's pulling, striling of the terminology. Testator is the person who makes the will. Okay. So nothing fancy, nothing to get scared there. One other very common question which a lawyer will ask you is, अच्छा आपकी will में executor कौन होगा? Now let us first understand what is an executor, who is an executor, and who ideally can be appointed as an executor. To start with, who is an executor? So executor वो इंसान है जिसका नाम आप वसीयत में लिखेंगे कि मेरे गुजर जाने के बाद मेरा भाई, मेरी बहन, मेरा फ्रेंड, whosoever, वो सब काम करेंगे जो वसीयत में लिखा गया है. ओके, आप वसीयत में क्या लिखेंगे कि मेरा घर मेरे बेटे को दे दीजिए, ज्वेलरी बेटी को दे दीजिए, फार्म हाउस है बेटे और बेटे में डिस्ट्रीब्यूट कर दीजिए. तो ये जो सब कौन करेगा? जिसने वसीयत बनाई है वो तो गुजर गए, तो ये जो सब एक्शनेबल आइटम्स करेंगे वो है वो इंसान एग्जीक्यूटर. ओके, so executor is the person who will do the action items which is written in the will. अभी ये कौन हो सकता है executor? The law does not provide, कानून कुछ लिखता नहीं है कि वो भाई ही होना चाहिए, immediate family ही होना चाहिए, blood relation होना चाहिए. No, but someone who is trustworthy. Now why trustworthy? Obviously because उस इंसान के हाथ में आप पूरा पावर दे रहे हैं कि ओके मैं तो लिख के गया हूं बट मैं तो चला गया, वो सब बराबर डिस्ट्रीब्यूशन प्रॉपर्टी हुई कि नहीं वो सब वो इंसान देखेंगे, कंफर्म करेंगे, चेक करेंगे. So someone who's trustworthy, someone whom you can rely on even in your absence, is a person whom you will choose to be the executor. Now same जैसे मैंने आपको testator testatrix में समझाया, executor executrix, अगर मुझे executrix बनाते हो आप तो because I am a lady it is executrix, if it is Nimish sir it will be executor. Okay, it's thrilling pulling of the same word.
So Chaital,
Okay.
sorry,
Yes.
stepping in since you are talking
Tell
about
me.
executor. So I think it's
Yeah.
important to highlight that minor cannot be a executor.
Yes, that's
So
correct.
just throw a light on that.
Minor as well as a person of unsound mind,
Correct.
both of them, they cannot be executors. So coming to who can be an executor, someone who's of major age, which is 18 plus, someone who's of stable mind, so a person of unsound mind, जिनको दिमागी कोई बीमारी रहेगी, तो वो नहीं बन सकते. Someone whom you trust. It need not be a relative. It can be your family doctor. It can be your family lawyer. It can be your trustworthy friend. It can be anyone who knows you for many years and whom you can trust. So these are the primary requirements of a executor that you need to be careful when you are appointing someone. Now there are further terminologies, दूसरे ऐसे शब्द हैं जो विल बनाते वक्त आपको आपका वकील पूछेगा कि ओके बेनिफिशियरी कौन है. बेनिफिशियरी सिंपली मीन्स कि आपका सपोज एक घर है, ओके, वो घर आप किसको देना चाहते हैं. So that person who will receive the house will be the beneficiary. Now that beneficiary need not necessarily be your relative. जरूरी नहीं है कि वसीहत में आप जो भी आपकी संपत्ति रहेगी वो आप अपने ब्लड रिलेटिव को ही दे. आप किसी को भी दे सकते हैं, वो आपकी इच्छा है. Here, please let me mention, this is subject to certain personal laws applicable to individuals of a particular faith. Okay, so certain cases में ये लागू नहीं होगा. Majority cases में ये लागू है कि will बनाने वाले को total freedom है कि उनको जिनको संपत्ति देनी है वो उनको दे सकते हैं. So I hope Bhakti, this clarifies the a few typical term and terminologies that we ideally use whilst making a will.
Yes. So you just mentioned that it's always good to have a trustworthy person as the executor. So
Yeah.
what other benefits would be there? Like you just said that so that there are no disputes later after the death of the testator or testatrix. What other benefits, such as to avoid disputes between legal heirs? What
See,
other examples are for like good benefits of making a will?
See, the primary benefit of making a will be two. One, you already mentioned, that is to avoid disputes between the family members. And the second most, rather, I would say the first most important thing is, today, if I have worked hard all my life to build a particular asset, I should have the right to decide whom it should go to after my death. Now, this is possible only if you write it down in a will, because if you don't write this in a will, the distribution of assets will happen as per the personal law that applies to you. I'll break this down. अगर हम हिंदू हैं, will नहीं बनाई है, okay, let's presume will नहीं बनाई है, तो अगर हम हिंदू हैं तो हिंदू लॉ अप्लाई होगा. क्रिश्चियन है तो क्रिश्चियन लॉ अप्लाई होगा. मोमेडन है तो मोमेडन लॉ अप्लाई होगा. तो उस हिसाब से अगर हिंदू में लिखा गया है कि अगर कोई इंसान विल नहीं बना के जाता तो वो प्रॉपर्टी 1/3 1/3 1/3 हस्बैंड और चिल्ड्रन में डिस्ट्रीब्यूट होगी. आई एम जस्ट हाइपोथेटिकली आई एम सेइंग, द फैक्ट्स मे बी डिफरेंट. अगर मोमेडन है तो उसमें 1/4 1/4 डिस्ट्रीब्यूट होगा. तो अगर आप ये नहीं चाहते, इफ यू वांट एब्सोल्यूट क्लैरिटी कि ओके मेरे बाद आई एम क्लियर, मेरा घर जाना चाहिए मेरी वाइफ को या मेरे बेटे को, तो विल बनाना बहुत जरूरी है. सेकेंडली, एज यू राइटली पॉइंटेड आउट भक्ति, इट्स एक्सट्रीमली इंपॉर्टेंट टू अवॉइड फैमिली डिस्प्यूट्स. विल में लिख दिया है कि भाई ऐसा डिस्ट्रीब्यूट करना है, फिनिश, you know, then that considerably reduces the chances of disputes between family members. So these two would be the primary reasons why we always urge people to make and leave behind a will.
Right. So you rightly pointed out that you should be clear as to the distribution of your property. Now, what if you are forced by someone to sign on the will, or you are just given a threat, you are coerced, you are under undue influence? So will that will be valid?
No. Connected to your question, let us in detail Also look at what are the essentials of a valid will. Okay, एक वसीयत कभी लॉ में वैलिड मानी जाएगी. One is that it has to be written. For common people like you, me, Dhruti, we can't make oral wills. Will has to be in writing. Okay, who are allowed to make oral wills, if you would ask me? Army men, navy men, air force personnel, when they are amidst a fight, when they are amidst a war, at that point in time, in that situation, if in unfortunate circumstances they know that okay, death is near, then they are allowed to make an oral will in the presence of two people around them. But for common laymen, we cannot make oral wills. We have to make the will in writing. अब जब मैं बोल रही हूँ कि विल राइटिंग में होनी चाहिए, इसका मतलब ये नहीं है कि आप अपने हैंडराइटिंग में लिखे. It just has to be written, so it can be typed, it can be in your handwriting, it can be in your lawyer's handwriting, either of the ways. Second, most important thing, a will can be made by a person only of 18 years and above. Minor will nahi bana sakte. Okay. Third important thing, the person should be of sound mind. अगर किसी इंसान को अनफॉर्चुनेटली कोई दिमागी बीमारी है, तो वो अपनी वसीयत नहीं बना सकते, because of obvious reason that they do not have the mental capacity to make a will. They do not unfortunately understand what is right, what is wrong, what is it that they want to do, or what is it that they should ideally do. So such a person cannot make, are not supposed to make a will. That would not be a valid will. Fourth most important is the will has to be made by free consent. आपको will बनानी है तो ही आप will बनाइए. Just because I am pressurizing you, Bhakti, you make a will and in that will you give your flat to me. No, that will is not valid because it is under undue force and coercion. So that is a invalid will. Okay. Fifth most important point is, if I am making a will, मैंने मेरी वसीयत बनाई है, मुझे पूरा क्लियरली समझ में आना चाहिए कि what I have written in the will. Okay. After, usually when we draft a will for a client, we always call the client, भाई आप हमारे साथ बैठे, you please go through what we have written. We actually narrate the will. This is what we've written. We tell them, please read it. Once they've clearly understood what they have written is when we sign off that, okay, the person has clearly understood and it is as per their free consent that they are making the will. So these 5 points are something which is extremely essential for a valid will which stands good under the law.
So in your this answer, you not only cover the essentials, but also types of will. So
Yes.
how would you execute a will? Is there a particular process you have to follow, and how many witnesses would you require for your will?
So ideally 2 witnesses are required. Now one, एक बहुत ही महत्वपूर्ण बात है जो प्लीज ध्यान में रखें. मैंने आपको एक्सप्लेन किया कि विल में बेनिफिशियरी कौन होता है. अगेन टू रिपीट, बेनिफिशियरी समवन जिसको कोई संपत्ति मिल रही है विल के अंदर. ओके, वेरी इंपॉर्टेंट. जो किसी को भी कोई संपत्ति मिल रही है विल में, वो सेम इंसान विटनेस नहीं हो सकता. So always remember this. Now tomorrow, if in my will, I am giving my flat to my son cannot be the witness to my will. This is a legal requirement. Okay? अगर वो witness रहेगा तो वो will invalid हो जाएगी. Sorry, the bequeathal will become invalid. तो वो जो flat मैंने छोड़ा है उनके नाम पे, वो उनको नहीं मिलेगा. The beneficiary will not get the asset mentioned in the will. So this is one very important thing that needs to be borne in mind. So 2 witnesses required. As I mentioned, the witness cannot be the beneficiary. Third important thing is the witness has to sign the will, put their signature on the will, saying ki, okay, my name is so and so, my address is so and so. Usually we always tell them to write the relation also with the testator. भाई क्या है, भाई है, बहन है, माँ है, बाप है, friend है, doctor है, कौन है, and that they have seen the person who is making the will sign the will in their presence. Simple words, agar main will bana rahi hu and Dhruti and Bhakti, you are the witnesses, then you will sign as a witness in my presence, and I will sign as a person making the will testatrix in your presence. And both the witness have to be present at the same time. ऐसे नहीं कि भक्ति आई साइन करके चली गई, बाद में ध्रुति आई और साइन करके चली गई. No, all three of us have to be present at the same time and sign in each other's presence. So as far as the witness is concerned, these are the three main aspects that one needs to bear in mind. And obviously, again, the witness has to be 18 years and above and someone of sound mind, so that they understand what is it that they are placing their signature on.
Right. So after having covered what is a will, essentials, execution requirements, and witness, now the common question which I'm sure most of our participants will have, do you need to make it on a stamp paper or is it required to be notarized? Because I'm sure it's a common question all over.
I completely agree. In fact, that's always the first question that comes कि okay, stamp कितने का stamp paper लगेगा, कि notary कराना पड़ेगा कि नहीं. So please bear in mind, a will need not be on a stamp paper. Plain white paper is also fine. Notary कराने की जरूरत नहीं है. Now, since this question has come up, I will dive a little further deep, and I will also tell you, I'm sure that would be Bhakti's next question, and that is again a very, very common question that we get asked, which is it mandatory to register a will?
Yes.
Okay. So it is not mandatory to register a will under the law, but जहां पे chances है कि भाई already family में disputes चल रहे हैं, और if the client tells us कि भाई जब तक मैं हूं तब तक मेरी फैमिली ठीक रहेगी, बच्चे ठीक रहेंगे, मुझे पता है मेरे जाने के बाद डिशुम डिशुम चालू हो जाएगा. तो in such circumstances, we always recommend the client that you go and register the will. Okay. How does that help? If I am making a will and you two are the witnesses, all three of us will go to the sub registrar's office. Now, ये कौन सी ऑफिस है? ये सेम ऑफिस है जहां पे आपने अगर फ्लैट खरीदा बेचा, जमीन खरीदी बेची, तो आप जो अपने एरिया के सब रजिस्ट्रार के ऑफिस में जाएंगे, वो फ्लैट अग्रीमेंट रजिस्टर करने या अग्रीमेंट फॉर सेल या लीव एंड लाइसेंस रजिस्टर करने. It's the same office where Dhruti, Bhakti and I will go, and three of us will sign the will in the presence of the sub registrar. Okay. And the sub registrar will then keep one copy with him in the locker and one copy comes to me. So that adds to the authenticity of the will कि भाई मेरे पे कोई force नहीं था. जब मैं will sign करने गई थी registrar के पास, one important thing which needs to be borne in mind is if will register करानी है, तो medical certificate is compulsory. आपको डॉक्टर के पास से एक सर्टिफिकेट लगता है स्टेटिंग कि भाई ओके, दिस पर्सन इज ऑफ साउंड माइंड, दिस पर्सन अंडरस्टैंड्स व्हाट ही और शी इज डूइंग, एंड दिस पर्सन हैज अंडरस्टूड द कंटेंट्स ऑफ द विल, and that he or she has no mental incapacity. So that certificate के बिना will register नहीं होगी. Okay, so that further adds to the कंटेंशन कि भाई जब भी इन्होंने विल बनाई, उनको कोई फोर्स नहीं किया गया था, उनको कोई दिमागी प्रॉब्लम नहीं था, उन्होंने अपने फ्री विल और कंसेंट से ये विल बनाई थी और रजिस्टर की गई है. सो Whether a registration is mandatory or no, it is not. But only where we think that there are chances of dispute is where we recommend that please get it registered.
So you have rightfully
Bhakti,
covered the aspects. Yes, sir.
Bhakti, I'll just step in here. I think there are a couple
Yeah.
of questions which have come up.
Yeah.
One question is that what will happen, in case executor turned unsound mind after death of testator? So I just replied that in such case, go to the probate court and, request for the replacement of executor. Sometimes, people also appoint joint executor. So,
Yeah. So
to avoid a
usually,
situation. Yeah, Bhakti, sorry, Chaital, if you would like to take it up.
yeah.
Second question which has come up, that what will happen if in case there is a death of one witness before, the testator. That is the second aspect, Chaital, you can cover up. And third is whether we need a doctor to be, advisable to have a doctor as a witness.
It's always better to have a family doctor as a witness, but again, not mandatory. In terms of executor, जो question आया था, what we always tell people is, usually what we do is, सिर्फ एक नाम मत लिखिए executor का, at least 2 या 3 नाम दीजिए. So, if I am making a will, I will say that Dhruti will be my executor. If she is not there when I pass away, Bhakti will be the executor. If Bhakti and Dhruti both are not there, then Nimish sir will be the executor. So we always advise people, kam se kam 2 to dijiye, preferably 3. Okay. Now, worst case situation, if all 3 have predeceased me, then what will happen is, at the time, I will have to go to the court, the probate court, and I will then, jo bhi mere heirs rahenge, like my son, my spouse, my parents, whosoever is alive at that point in time, they will go and apply to the court and say that, okay, ye executors likhe the, but they are no more. So therefore, appoint one of us as the executors to the will. So that is the process which happens when there is no, when the executors under the will either become mentally unstable, or they predecease, or they die before the person who makes the will. The third was, sorry, there was a third question as well. Could Nimish sir or Bhakti, can you just help me? What was that?
If the witness died before the...
If the witness dies before the person making the will, again, when we come to the little later stage of probate, LA and succession, when I explain that process to you, is when I would like to take up this question as to what happens when a witness predeceases the testator. So I'll just park that question aside for a while and I'll take it up a little later.
So, Chaital, there are a few clarification with the participants require. One would be that, we have a 3-party usually involved: testator, executor, and witness. I would like to know that can a executor be a beneficiary?
Yes.
So who could be, if you can just...
Beneficiary can be an executor. Executor can be a beneficiary. Just remember one thing that is not allowed, because that's the way even we remember. It's the simplest thing. Beneficiary and witness cannot be the same. Okay. Other permutation combinations are allowed. Executor can be the beneficiary, but beneficiary and witness cannot be the same. Executor and witness also can be the same, but we always recommend to have separate executors and separate witnesses, just to keep it clean and simple.
Yeah, thank you, Chaital. And on, since you discussed about registration, I think one interesting question which has come up, that what will, how do you register the will when you are, say, mortgage your property? So still you can continue and do your will and register the property.
Yes, definitely.
Absolutely.
Mortgaging of property would not really be a hindrance in you preparing your will. See, जब भी आप will बनाते हैं, so you will write कि this property, which is currently mortgaged with so and so, as and when the mortgage is clear, would then go to XYZ or whosoever. Okay. And there's absolutely no bar in you going and registering that will, knowing कि already जो property आपने will में लिखी गई है उसका registered mortgage है. That is not a bar. Absolutely not a bar. That's doable.
And other question which has come up is it become a public document like, when you
No,
registered a property? Correct.
no, no, no.
Yeah.
It's kept in lock and key and it comes out only when the person passes away. So आप normally जैसे, if suppose I'm buying a flat, we usually do a search at the registrar's office. So वो will उसमें, it's not a part of a public search document.
Chaital, I'm just asking you out of curiosity that have you come across situation even after registration, there is a family dispute and people question the registration,
Yes,
registered will?
yes, yes. It's not uncommon ki, see, because typically, as I mentioned, in only those cases we recommend registration जहाँ पे हमको पता है कि problem आने वाला है future में. So it's very common कि will registered है, फिर भी the branch, the heir, the beneficiary जिसको नहीं मिला है will के अंदर, they will go and file a case in the court saying कि ये will force से बनाई गई थी.
It's just
So,
add a layer to a security, correct?
yes,
The registered,
yes,
it's add a layer.
yes, yes. Yeah, Bhakti.
Yeah, so having covered the stamp duty aspect and the notarized aspect and the registration aspect, my next question would be to Nimish sir. So, are there any tax implications with respect to a will?
No tax implication when any property bequeathed to the beneficiary. Section 47(3) of income tax categorically exempts such situation. So there won't be any tax liability if the property is bequeathed to the beneficiary.
Great, so thank you. Heading back to Chaital ma'am, so you have explained us what is a will, and what if tomorrow you want to change your will, you want to make some additions or alterations. So how would someone go about that?
See, there are two options, Bhakti. How do you do that? One is either that you scrap the will and you make a new will altogether, or many a times क्या होता है कि will पूरी बना के रखी है and suppose एक flat will में लिखा था वो मैंने बेच दिया, या फिर मैंने नया flat खरीद लिया, or there is some addition in my assets. So rather than tearing away the full will, what we do is we make an amendment to the will. And that amendment to the will is called a codicil. Okay. Now, please remember, as we just discussed about a will being registered, अगर आपने original will register की है और अगर आप वो will amend करते हो via a codicil, so you will have to register the codicil as well. Or if you've registered a will and you feel अरे नहीं वो मुझे amendment नहीं करना, confusion होगा, I will make a new fresh will by itself. So then you will have to go and register that fresh will, because otherwise what you will make is the will that will be with you, and what is registered with the sub-registrar will be a different will. So whenever a will is registered, if there is any amendment, we need to be extremely careful and make sure that that amendment also gets registered.
Right. So, having spoken about what is a will, its types, its stamp duty, notarization, registration, tax implications, now let's come to what happens after a will. So, after you made the will and you expire, how is your property mentioned in the will distributed amongst the beneficiaries? If you can just
Bhakti,
explain it to our
Bhakti,
participants.
sorry, I think on a codicil there is a question which has come up. So I thought it's relevant, so we'll take it up that
Yeah.
Person make a will, keeping in mind his existing property, correct? Now, subsequently, after making a will, he buys other property or some shares, etc. So in such case, how it works in a sense that if your will already provides that all future property should go to XYZ, though even that property which is not acquired, Okay. Though that property is not mentioned in your will, since you mentioned that XYZ is entitled for all my future property will go to XYZ. But but it is advisable that, in case you want to be too specific, amend your will, especially when the value involved is higher. Am I right, Chaital?
Correct, absolutely right, Nimish sir. So basically, how we deal with this is if there is any addition in shares or subscriptions or movable assets per se, where the value is not enough and where the person would want it to go to the beneficiary written in the original will, we don't change the will. So in every will, there is a clause, एक डाला जाता है, which is called a residuary clause. तो उसमें क्या मेंशन करते हैं कि भाई ऊपर जो एसेट्स लिखे हैं उसके अलावा भी अगर व्हेन आई डाई मेरे पास कोई और संपत्ति है तो वो एबीसी को जानी चाहिए. नाउ सपोज आफ्टर वो वसीयत बनाने के बाद मैंने फिक्स्ड डिपॉजिट्स दूसरे बनाए, आई इन्वेस्टेड सम मनी इन शेयर्स which is okay, which is not substantial, then I am okay it going to ABC under the residuary clause. But if I bought a house, if I bought a fancy car, if I bought some jewelry of high value, then I may, depends upon the facts of each case, I may want to change my will to say कि नहीं भाई ये तो XYZ को जाना चाहिए, ABC को residuary में नहीं जाना चाहिए. तो in that case will को amend करना ही पड़ेगा. There is no other option. So yeah. Bhakti, what was your question next? Or are there any other questions in the chat box, Nimish
Yeah, so
bhai?
there are several questions and I'm answering them as and when come up, and I think I'll keep answering
Sure.
whichever I may find it relevant, appropriate topic. Otherwise, if I feel that आपने already if you are taking up those questions at a subsequent, in the discussion, then I'm not answering those questions,
Understood.
but otherwise I'm answering the such questions. But one question which has come up about the executor. What if, the executor is staying outside India? So I just replied कि outside India का कोई executor रहेगा, तो अभी will execute करने के लिए उसको India आना पड़ेगा. That person is to act as per the instruction mentioned in the will. So maybe he needs to stay in India. So the critical part which may come up is that अगर वो इंडिया में ज्यादा रह गया तो probably उसका residential status change हो जाएगा, तो taxation change हो जाएगा. So you need to be little mindful when you select the executor.
Executor, correct, absolutely right.
So I think Bhakti, now you can take it forward, and if at all there are any questions, ऐसे कुछ आते हैं, तो I'll just step in, but otherwise I'll keep answering.
Sure, sir, noted. So, Chaital ma'am, my question was that we have discussed everything with respect to the will, codicil, its registration, etc. So now what happens to the properties after the testator or testatrix has expired? How will it be distributed amongst the beneficiaries?
See, under the law, for a Hindu, Parsi, Sikh, Jain, the only people who are exempt is Christians and Mohammedans. Except Christians and Mohammedans, people of all other faith, either residing in Bombay, Madras, which is Chennai, or Calcutta, or the property is situated in these three jurisdictions, or they died in these three jurisdictions, then they have to approach the local high court and obtain a probate or a letters of administration or a succession certificate. I know it sounds like एकदम भारी भरकम legal words डाल दिए हैं मैंने सबके ऊपर, but I will explain in layman terms what these documentation are. Please understand the process for these three documents are the same. The time taken to obtain these documents from the High Court is the same. The court fee payable for these three are the same. The only thing that differs is the name. So there are three things: probate, letters of administration, succession. Now, what is the difference between the three when all are same? If I have made a will, I staying in Bombay, my flat is in Bombay, I died in Bombay. I will go to the Bombay High Court, and if there is a will, the document that I will take from, I mean, not I, the executor will take from Bombay High Court is a probate. Okay. So where there is a will, there is a probate. Where there is no will, but the assets have immovable properties and movable properties, the document which I will take from court is LA, which is letters of administration. When there is a will and there is no immovable property, or if there is no will, then the document that I will obtain is a succession certificate. So simple way to remember, will है तो will है, movable immovable assets है तो probate है, will नहीं है तो LA होगा, और will है या will नहीं है but only movables है तो succession होगा. This may be a little difficult for you all to understand, but in essence there are these three documents that the executor will have to go to the court and obtain. और एक बार वो document मिल गया executor को, only after that he or she can distribute the assets as mentioned in the will. Suppose I make a will and I die tomorrow, okay? And Bhakti is the executor mentioned. On the 10th or 11th day, Bhakti cannot go and distribute my assets. She will have to go and approach the Bombay High Court. She will have to make an application for probate. Only 6-8 महीने के बाद जब probate आएगा भक्ति के हाथ में, is when she will be able to do the distribution, which is mentioned in my will. So again, please remember, these probate, LA and succession are required for people following faith, Hindu, Parsi, Sikh, Jains. Okay, people following these faith, and either they are residing in Mumbai, Chennai, Calcutta, or the property is in these three states, or they died in these three states. So ये condition comply करना जरूरी है. Only then the local court gets the jurisdiction. So if I am a Christian, say for example, and I have made a will, there is no need for me to go to the Bombay High Court, even if I'm living in Bombay, कि भाई मुझे probate दे दो. I am exempt. The law has exempted me. If I am a Mohammedan, similarly, I have made a will. The executor does not have to go to the court. There is no need for them to obtain these documents. So I hope I've explained it, and it's clear when these documents are required and to whom these provisions of law are applicable. Now, yeah, here one question was regarding the witness. Just in a minute to explain, जो documentation executor file करेगा before the let's say before the Bombay High Court, तो उसमें तो पहले वो petition आएगा. That petition has to be supported by the witness affidavit, so that if Bhakti and Dhruti are alive and they are witnesses to my will, they will have to give a witness affidavit to my executor saying that yes, Chaital had signed in my presence and we had signed in her presence, and she understood the contents of a will. Now, suppose if any of them predeceases me, then we will have to take their death certificate, and accordingly an affidavit will have to be filed by the executor saying that the so-and-so is already predeceased and this is the proof of death. So I hope I've answered the query regarding the witness predeceasing the executor.
Right. So would it be advisable to make a gift deed? Like, for example, you want your properties distributed as per you when you are alive, compared to you making a will and then your executors distributing. So would a gift deed be advisable for you to distribute all your assets before your death?
See, it's extremely difficult for me to answer that. Why? It all depends on the facts and circumstances of each case. I'll give you an example which I just came across recently. The family, the children came to me and said, ki nahi, the parents want to do the gift deed of their flat, in one flat in my favor, the other flat in my brother's favor. And later we got to know that the parents never wanted to give away the flat via gift deed. Rather, they wanted to enjoy it whilst they were alive and give the flats to the children only after they pass away under a will. So two ways to look at it, depending on the facts, depending on the family dynamics. One person may prefer कि भाई जब तक मैं जिंदा हूं मैं तभी के तभी दे दूं उनको. So gift will come into effect immediately. Okay. Today, if I gift my flat to the son, the day I register the document, my son becomes the owner. Whereas if I give him the flat under a will, when will it come into force? Only after I die. So whilst I am alive, I am the owner and I reap the benefits of the flat. So it would be extremely difficult for me to say whether, I mean, as a standard answer, in which case, which would be advisable. It all depends on the facts of each case. Also, in case of a gift, one needs to bear in mind the stamp duty implication on a transfer of property. Please remember, if it is a residential flat, okay, if I'm giving my residential flat to my son, I am exempted from stamp duty. So I will pay only 200 rupees as stamp duty, but 1% metro cess on the market value will be applicable. Now, extremely important, if I give my residential flat to my parent, that is not exempt. It is only me, my spouse, or my lineal descendant. Lineal descendant means my generation after me. But the generation before me, अगर मैंने मेरी mom को दिया flat, तो उस पे पूरा stamp duty applicable होगा. Okay? If it is a commercial premises, then what happens? If it's commercial premises, then now here the stamp duty is 3% of the market value plus 1% metro cess. So 4%. But in this case, whether I give it to my parent or my husband or my child or my grandchild, same provision for everyone. So these are the stamp duty that is applicable on residential. There is a mega discount, so to say, and on commercial it is lesser than 6%, which is the normal conveyance. It's 4%.
Right. So further to this, I would like to ask Nimish sir, so are there any tax implications with respect to the gift deed?
Yeah, so Bhakti, first of all, just to extend explanation of Chaital, in case the person making a will testator feels that there are chances of any kind of a family dispute, especially when you have many property, and they feel that there are chances of dispute subsequent to the person passes away. So to maintain harmony of the family, sometimes people make a gift deed and pass on certain assets during the lifetime. That also we have seen. Now to come on the taxation aspect, yes. So when the gift is made only within the family members defined under the Income Tax Act, there is no taxation. It will not amount to transfer, no taxability. But if the gift is made to the person outside the family member, suppose under the will you bequeath the property to say a friend also, there is no tax implication. But when you're gifting your property to a friend, it is a taxable event. In such case, the person who is receiving it will be taxed under income from other sources. It is applicable at the normal Income Tax Act. Is applicable.
I'm sure this must have solved a lot of questions in people's mind with respect to stamp duty issues. Also, we have received some questions at the time of registration of this webinar. One question is from Ms. Hiloni Cheda. In situations where a person has made a will, nominated someone on financial assets, and also gifted a property during their lifetime, how does law prioritize these instruments in case of a dispute, and what practical steps can one take to avoid future legal conflict amongst their heirs?
See, one important thing which requires a mention here is very often people think कि भाई nomination डाल दिया society में flat के लिए तो हो गया, will बनाने की जरूरत नहीं है. बैंक में nomination डाल दिया, DP के पास nomination डाल दिया, mutual fund में nomination डाल दिया, and that's the end of the story. Please remember, a nominee is always a trustee. A nominee does not become the owner. The owner will be the, अगर आपने will बनाई है तो will always supersede all the other nominations, whether it is with the society, bank or DP, mutual fund, जो भी है, the will override. So under the will, if I've given my bank deposits to my son, but with the bank, the nomination is in my husband's name, the will ke hisab se the bank will give it to my son and they will not give it to my husband. And even if in the interim they give it to my husband will hold it as a trustee. He will not hold it as the ultimate beneficiary or the ultimate owner. Okay. So to answer Hiloni's question, today if I've made a will, in the will I have written my flat goes to my son. After a year or two, I decided, nahi chal, mujhe gift de dena hai. Whilst I am alive and I gifted that property to my son. The gift comes into effect immediately the day the document gets registered. To that effect, that bequeathal, the property that is there in my will become invalid because वो property already मैंने gift कर दी है. So that gift comes into effect immediately. Nomination, please remember, wherever nomination is filed, the will override the nomination. Even if there are different nominations in the will and bank, society, mutual fund, whatever is written in the will override.
Bhakti, over and above, sorry, Chaital, over and above, there is a couple of questions. I think let's answer it. And I want to highlight one point for the audience. One question is about the ancestral property, you know, how it works under Hindu Succession Act. That is the first question. And the second question is about release deed and a probate. So we need with release deed, can the property be transferred or we need to go to court and get it?
No, like say for example, I and my husband jointly own the flat where we reside. If tomorrow I want to make him the 100% owner, then I can release my share by a registered release deed in his favor. So the minute the release deed is registered, he then becomes the 100% owner of the flat. So there I don't need to go to the court.
No, agree. Right? The question is that post demise of a person, you know.
The post demise, it will go only and only as per the will, if there is a will. And if there is no will, then it will go as per the personal laws. So if the person is a Hindu, so suppose if I am 50% and I die and I have not made a will, then my share as per the Hindu Succession Act will go 1/3 to my mother, 1/3 to my child, and 1/3 to my husband. So usme fir release deed, these people will have to do to whosoever that they want to release the share or in whose favor.
Sure. And also there is a question on ancestral property, how it works. So I replied that if I receive ancestral property, either through gift or through will, then I have a power to, you know, consider that property as my property and
Yes.
make the will.
Yes, absolutely.
In case you wish to highlight that further.
No, that's perfectly fine. It's you have to treat it like it's your own property, and you are free to give it away and deal with it in the way you desire.
Yeah. Chaital, then we can also have a situation where A and B are two joint owners. Okay. Now, in such case, if A passes away, that does not mean that B will become the absolute owner. Correct?
No. Yes,
Yeah. So the
absolutely
legal
right.
heirs of A will get the 50% or whatever they
Yes.
share in the property.
Yes. As I just mentioned, today, if I and my husband are 50-50 in the flat, and if I die without a will, then my 50% will 1/3 go to my mother if she's there, my husband if he's there, and my child. And the 50% remains with my husband, which was his ownership.
Right. So there are a couple of more questions which we have received at the time of registration. One is from Mr. Nimish Khakhar. Any way where a probate is not required, but a registered will can be done, or if a specific power of attorney given only executable post death who makes will.
Power of attorney can't be given to be come into effect post death. The minute you've issued a power of attorney and the person who's, if I've given a power of attorney to Bhakti saying that, okay, because of whatever reasons, I'm not in the country, I'm not keeping well, you do ABC, the minute I die, the power of attorney comes to an end. So there's no concept in law of a power of attorney being active after a person dies. Secondly, if the law of probate applies to you, that is, as I mentioned, Chennai, Calcutta, Mumbai, if the law of probate applies to you, there is no escape. One will have to obtain that documentation from the concerned High Court. And
One
yeah, go ahead. Go ahead, Bhakti.
Yeah, one other question we received is from Miss Furia. Gift to real unmarried sister, whether that is permissible.
Yeah. Yes. So it will then the stamp duty, depending on commercial or residential, as we discussed, it will be either 1% plus 200 rupees or 3% plus 1% metro cess for commercial. Are there any further questions on the chat or are answered?
I think the question again is on a release deed and probate that we have seen that in the past that after the death of a person who has made a will, so family instead of making a probate, they prepare a release deed in the favor of a particular person. Okay. Say for example, husband, wife, and they have a say 2, 3 children. In such case, after the death of say husband, their children release their rights in the favor of mother. So in such case, whether the release deed will suffice or do we need to go to court to obtain the probate? That's the question which has come.
See, ideally, again, at the cost of repetition, if the law of probate, LA and succession applies to that individual, then that is the legal way for them to proceed. If
Correct.
suppose the property is, say, for example, in Kerala or it is in Gujarat where these provisions do not apply, then the release deed would be the ideal way forward. But if it is a property in Mumbai or if the person died in Mumbai, then probate and LA is the only way further.
I think practically, many times people take a practical call whereby they execute a release deed and register it, and that's not
Exactly.
practical in just to avoid the time, for getting a probate and the cost of incurring probate.
I completely agree. See, probate LA is a time consuming and an expensive affair. However, initially, like before a year, the cooperative society managing committees also used to not insist on probate LA before transmitting the flats. But about a year and a half back, the Registrar of Cooperative Societies has issued a circular whereby he's made it mandatory on the managing committee of all the societies that if you transmit the flat without probate LA, then you will be responsible for all the penalty under the law. So initially, the managing committee of the societies, now say for example, the flat where I grew up, the society members knew us, everybody's been living there for 40 years. So nobody insisted that, you go get a probate, you go get a LA. But that was the situation in the past, despite the law saying that yes, it is mandatory. But now with the mandate coming from the cooperative registrar as well, the managing committee of the cooperative housing societies are left with no option. So even in the case of release deed that you mentioned, कि भाई चलो release deed कर ही ली थी, but even in that case, the managing committee, if they insist कि no will छे probate जोइसे कि will नथी तो LA जोइसे, they will have no option but to go and obtain that from the court, because that is the legal way further.
Chaital, there are questions, 2, 3 questions on who should keep the will, and I mentioned that ideally the person who is making the will keep the will at a safe place and mention someone unknown to him that where he has kept the will. The questions are that whether it should be with the executor, whether it should be beneficiary, if you want to throw light on it.
See, there's no legal answer to this, but a practical answer to this would be we usually give one copy to the executor, because the executor, first of all, we always ask for the permission. Okay, by tomorrow, if I'm appointing Bhakti, I need to inform and check with Bhakti. Bhakti, are you comfortable being my executor? So once she says yes, then if I've made a will naming her as an executor, I will keep one copy with her. And we always tell the clients, keep one copy in your house safe or in the bank locker. So these two are the ideal places. Or if you have a family lawyer or a family CA, then normally many people prefer to keep the wills even with these two offices, either the lawyer or the chartered accountant. But executor, we always prefer to give them a will, because the minute the person dies, it is the executor's responsibility to open the will and narrate the contents to the family of the deceased.
Yeah, Bhakti, you can move forward.
Yeah.
Bhakti, any more
So
questions?
someone has again asked for a clarification with respect to stamp duty for residential flat. So if you could please repeat that.
But for what? Gift?
Yeah.
No, yeah.
So for gift for a residential flat, either from husband to wife or wife to husband, that is to spouse, one spouse to another spouse, or to lineal descendant, which is to children or grandchildren, will be on 200 rupees plus 1% metro cess. Metro cess is on the market value of the property.
Yeah, so please note that the discussion that we're having today is a general discussion and it may not be applicable to any particular matter. We strongly advise you, in case you have any concerns, please take professional advice. Now, after this insightful session, I'm sure सबको बहुत कुछ जानने और सीखने मिला होगा. Before we wrap up, I want to take a moment to express my heartfelt thanks, first and foremost, to our incredible speakers whose insights and expertise truly made this session valuable and engaging. Thank you, Chaital ma'am, thank you, Bhakti, and thank you, Nimish sir. Secondly, I would like to thank our organizers and behind the scenes team. Your hard work made this webinar seamless. Wouldn't have been a success without your support. And lastly, to our lovely, lovely audience, thank you for your time, your curiosity, and your thoughtful participation. We are truly grateful for presence, especially on a Saturday evening like this. Until next time, take care, stay connected, and keep following our LinkedIn page for more such valuable sessions. Thank you again. Goodbye for now. Shubh Ratri.
Thank you.
Thank you, everyone. Good night.
Thank you.